I knew something was wrong the moment I found the bright orange envelope wedged into my front door frame that Tuesday morning in Scottsdale, Arizona. The paper practically screamed at me, and when I pulled it out, the words "violation notice" were stamped across the top in bold red letters that looked like they'd been designed to induce immediate panic. My name is Stephen Norris, and I had just bought my first house 3 months earlier in the Saguaro Springs subdivision, a pleasant enough neighborhood with palm trees lining the streets and mountains visible in the distance. The house was a modest 3-bedroom ranch style with beige stucco walls and a red tile roof, pretty standard for Arizona. I worked as a software engineer for a tech company downtown, and after years of apartment living, I was thrilled to finally have my own place with a yard and a 2-car garage. I opened the envelope while standing on my driveway, the morning sun already beating down even though it was only 7:30. The notice claimed I was in violation of multiple HOA covenants and restrictions. According to the document, my mailbox was the wrong shade of bronze. My front door wreath exceeded the allowable decoration size by 4 inches, and my garbage cans had been visible from the street for more than 2 hours past the designated pickup time last Thursday. The fines listed at the bottom totaled $850. I read the notice 3 times, convinced I was misunderstanding something. My mailbox looked identical to every other mailbox on the street. The wreath was a simple arrangement my sister had given me as a housewarming gift, maybe 18 inches in diameter. And the garbage can thing was absurd because the truck had come late that day, and I had been at work, unable to rush home to hide plastic bins like some kind of trash ninja. The signature at the bottom belonged to someone named Patricia Cromwell, HOA board president. There was a phone number and an email address, along with a stern warning that failure to pay the fines within 14 days would result in additional penalties and possible legal action. I went inside and made coffee, trying to calm down before I did something stupid like call this Patricia person and tell her exactly where she could stick her violation notice. Instead, I pulled out the massive folder of documents I had received at closing. Somewhere in that stack of papers was the HOA covenant, conditions and restrictions document, commonly called the CCRs. It took me 20 minutes to find it buried beneath the title insurance policy and mortgage documents. The CCRs were 47 pages of single-spaced legal text that I had skimmed briefly before buying but had not memorized. I started reading through the sections related to exterior maintenance and architectural standards. The mailbox section specified that all mailboxes must be an approved bronze or copper finish. There was no specific shade mentioned, no color code, no reference standard. My mailbox was bronze. I had replaced the old rusty one myself 2 weeks after moving in, buying a standard bronze finished mailbox from Home Depot that matched what everyone else had. The section on door decorations stated that seasonal decorations of reasonable size and taste were permitted. That was it. No specific measurements, no definition of what constituted reasonable size. My wreath was completely ordinary, the kind you could buy at any craft store. The garbage can provision was even vaguer. It said cans should be returned to storage in a timely manner following collection. Timely manner could mean anything. 2 hours, 4 hours by end of day. The language was so broad it was essentially meaningless. I decided to call the number on the violation notice. A woman answered on the 3rd ring with a clipped HOA office. "Hi, my name is Stephen Norris, and I just received a violation notice that I think might be a mistake," I said, keeping my voice level and polite. "Hold, please." The line clicked before I could respond, Elevator music played for nearly 5 minutes before someone picked up again. "This is Patricia Cromwell. You are calling about a violation notice." The voice was sharp, businesslike, with an edge that suggested she did not expect to be questioned. "Yes, I received a notice this morning listing several violations and some pretty steep fines. I have looked through the CCRs, and I do not think I am actually in violation of anything. My mailbox matches everyone else's on the street. My wreath is a normal size, and the garbage can thing was because the truck came late. Mr. Norris, the violation notice clearly outlines the issues. Your mailbox is not the approved shade. I have personally inspected it. Your decoration exceeds the 14-inch maximum diameter specified in the guidelines, and garbage cans must be stored within 1 hour of collection. But the CCRs don't say any of that," I countered. "There's no specific shade mentioned, no 14-inch rule for decorations, and the garbage can section just says timely manner, which is not defined. The CCRs are supplemented by our architectural guidelines and board policies, which are provided to all homeowners. You should have received them." "I never received any architectural guidelines or board policies. I got the CCRs at closing, but that's it." Patricia's voice took on a patronizing tone. "Well, Mr. Norris, ignorance of the rules is not an excuse. The fines stand. You have 14 days to pay and correct the violations. If you wish to contest this, you may request a hearing with the board. But there is a $200 hearing fee, and if the board rules against you, you will be responsible for that fee plus the original fines plus any additional penalties that accrue." The casual way she mentioned additional fees made my blood pressure spike. "This does not seem right. I want copies of these architectural guidelines you are talking about. They are available for purchase at the HOA office for $35. Purchase. These are rules I am supposedly required to follow, and I have to pay to see them. That is our policy. The office is open Tuesdays and Thursdays from 10 to 2. Cash or check only." She hung up before I could respond. I sat there staring at my phone, trying to process what had just happened. This woman was claiming I was in violation of rules I had never seen, demanding hundreds of dollars in fines, and charging me money just to view the actual guidelines. The whole thing felt like a scam. I called my real estate agent, a friendly guy named Marcus, who had helped me find the house. He listened to my story and sighed heavily. "Yeah, Patricia Cromwell is notorious in Scottsdale. She has been the HOA president of Saguaro Springs for like 8 years, and she runs it like her personal fiefdom. I have had other clients have issues with her. The problem is that most people just pay the fines because fighting it seems like more trouble than it is worth. But can she actually enforce this stuff? The CCRs do not back up what she is saying. That is the thing. She is kind of banking on people not knowing their rights. HOAs have a lot of power in Arizona, but they are not unlimited. If the CCRs don't specifically state something, she cannot just make up rules. But she will try. My advice is to document everything, get copies of whatever guidelines she is citing, and if she pushes it, talk to a lawyer. Great." I had owned my house for 3 months, and I was already looking at potential legal fees. I decided to go to the HOA office on Thursday to get these mysterious architectural guidelines. The office was located in a small commercial building near the subdivision entrance, sharing space with a nail salon and a tax preparation service. I arrived at 10:15 and found a door with a plastic plaque that said, Saguaro Springs HOA. Inside was a cramped waiting room with 4 chairs and a reception desk where a tired-looking woman in her 60s sat typing on an ancient computer. She glanced up when I entered. "Help you. I am here to purchase a copy of the architectural guidelines. $35, cash or check. I pulled out $40 in cash. Can I also get a receipt? She counted out my change and wrote out a handwritten receipt on a generic receipt pad, then pulled a thin booklet from a drawer and handed it to me. The booklet was maybe 12 pages, photocopied and stapled together. I flipped through it quickly while standing at the counter. The entire thing was formatted like it had been written in Microsoft Word by someone with minimal computer skills. There were inconsistent fonts, random bolding, and sections that looked like they had been added at different times with different formatting. More importantly, the document was undated and had no official signatures, board approval stamps, or any indication of when or how it had been adopted. When was this adopted by the board? I asked the receptionist. She shrugged. No idea. I just work here part-time. You would have to ask Patricia. Is she here? She is in her office, but she is busy. You can leave a message. I decided not to push it and took the guidelines home to read carefully. What I found was even more concerning than the violation notice itself. The guidelines claimed to establish all kinds of specific rules that were not in the CCRs. Mailboxes had to be Sherwin-Williams bronze tone, SW 7034 or equivalent. Door decorations could not exceed 14 inches in any dimension. Garbage cans had to be stored within 1 hour of collection. There were dozens of other hyper-specific rules about everything from the exact height lawn grass could be before it was considered too tall to the acceptable color range for front door paint. But here was the problem. The CCRs, which I had now read cover to cover twice, stated that any amendments or supplemental rules had to be approved by a vote of the homeowners and filed with the county recorder's office. I called the Maricopa County Recorder's Office and asked if any amendments or supplemental documents had been filed for Saguaro Springs HOA. The clerk searched their system and came back with a negative. The only recorded documents were the original CCRs from when the subdivision was established in 1998 and one amendment from 2003 that dealt with expanding the number of board members from 3 to 5. Nothing about architectural guidelines, nothing recent. This meant Patricia's guidelines had no legal weight. She had essentially written her own rules without proper authority and was using them to fine homeowners. I started asking around the neighborhood. My next-door neighbor, a retired teacher named Frank, listened to my story and shook his head knowingly. Patricia has been pulling this stuff for years. She fined me $200 once because my garage door was open for more than 30 minutes during the day. Claimed it was an eyesore. I paid it because I didn't want the hassle, but yeah, she is on a power trip. Did you know these architectural guidelines were never properly adopted? Frank's eyebrows went up. No, I did not know that, but it does not surprise me. She runs board meetings like a dictatorship. Last time I went to one, she shut down anyone who tried to ask questions. I talked to several other neighbors over the next few days. A couple named Jim and Donna told me they had been fined for parking their car on the street overnight when they had family visiting. A single mom named Rachel had been hit with a $500 fine for letting her kids draw on the driveway with sidewalk chalk, which Patricia claimed violated the no graffiti provision of the CCRs. Another guy, Mike, had been fined because his house number plaque was mounted half an inch too far from the door frame according to Patricia's measurements. In every case, people had either paid the fines or were intimidated into compliance by threats of liens and legal action. No one had actually fought back because the process seemed designed to be expensive and exhausting. I decided I was not going to be another pushover. I drafted a formal response to the violation notice. citing the specific sections of the CCRs that were relevant, pointing out that the architectural guidelines had never been properly adopted, and explaining in detail why each alleged violation was baseless. I sent it via certified mail to ensure there was proof of delivery. 2 weeks went by with no response. Then another orange envelope appeared on my door. This one claimed I had ignored the previous violation notice and that my fines had now increased to $1,500 due to late penalties. It also stated that if I did not pay within 7 days, the HOA would file a lien against my property. I called a lawyer that afternoon. Her name was Jennifer Hayes, and she specialized in HOA disputes. I explained the situation, sent her copies of everything I had including the CCRs, the bogus architectural guidelines, the violation notices, and my written response. Jennifer called me back the next day. This is actually pretty clear-cut. The HOA cannot enforce rules that were never properly adopted. The CCRs specify a process for amendments and supplemental rules, and they did not follow it. These architectural guidelines are essentially worthless. As for the violation notices, if they tried to file a lien based on these fake violations, we could challenge it immediately and probably get sanctions against them for frivolous actions. So what should I do? Send them one more letter, this time from my office, explaining the legal deficiencies in their position and demanding they rescind the violations and cease any further enforcement actions. If they ignore that or try to proceed with a lien, we file suit. Honestly, I would love to take this case. HOAs like this give the legitimate ones a bad name, and someone needs to push back. Jennifer drafted a letter on her law firm letterhead that was beautifully written and absolutely devastating. It methodically dismantled every aspect of Patricia's violation notices, cited Arizona HOA law extensively, and made it clear that any attempt to proceed with liens or legal action would result in the HOA being sued for harassment, abuse of process, and violations of state law. She sent it certified mail with return receipt requested. Patricia signed for the letter on a Tuesday. By Friday, I received a phone call from a number I did not recognize. I answered cautiously. "Mr. Norris, this is Howard Baker. I am a member of the Saguaro Springs HOA board. I received a copy of the letter your attorney sent to Patricia, and I wanted to reach out to you directly." "Okay. I want to apologize for this situation." Several board members, myself included, were not aware of the extent to which Patricia has been issuing violation notices based on guidelines that were never properly approved. We are having an emergency board meeting next week to address this, and I wanted to assure you that we are taking this seriously. I appreciate that, Mr. Baker, but I have talked to a lot of neighbors, and it seems like Patricia has been doing this for years. How did the rest of the board not know? Howard sighed. That is a fair question. Honestly, Patricia handles most of the day-to-day operations, and the rest of us have been too hands-off. She presents reports at board meetings that make it sound like everything is routine enforcement, and we trusted her. That was a mistake on our part. So, what happens now? We are going to vote to rescind your violations and any fines associated with them. We are also going to conduct a full review of all violation notices issued in the past 2 years and determine which ones were based on improperly adopted guidelines. Those will be rescinded as well, and we are going to discuss Patricia's role going forward. She needs to be removed as president, I said bluntly. She has been abusing her position and extorting homeowners. I understand your frustration. That will be part of our discussion. I cannot promise any specific outcome, but I can tell you that several board members are very concerned about the legal liability she has exposed the HOA to. The emergency board meeting was scheduled for the following Thursday evening at 7. It was open to all homeowners, and word had spread through the neighborhood about what was happening. When I arrived at the community center where the meeting was held, the room was packed with at least 60 people, far more than usually attended. Patricia sat at a table at the front of the room with 4 other board members. She looked tense, her jaw clenched tight as she shuffled papers in front of her. Howard Baker was there, along with 2 women and another man whose names I did not know yet. Howard called the meeting to order and immediately addressed the elephant in the room. We are here tonight to discuss concerns that have been raised about HOA enforcement procedures and the validity of certain violation notices that have been issued to homeowners. We have conducted a preliminary review, and we have identified some serious issues that need to be addressed. Patricia interrupted, her voice sharp. This is completely unnecessary. I have been enforcing the rules as they are written. If certain homeowners do not like being held accountable for violations, that is not my problem. One of the other board members, a woman named Linda, shook her head. Patricia, we have been over this. The architectural guidelines you have been citing were never approved by the board or the homeowners. They were never filed with the county. You wrote them yourself and have been treating them as if they were binding law. Those guidelines are based on the CCRs. I was just clarifying the existing rules. You cannot clarify rules by creating entirely new specific requirements that do not appear anywhere in the recorded documents, Howard said firmly. And you have been issuing fines based on these unenforceable guidelines, which exposes the HOA to significant legal liability. I raised my hand and was recognized to speak. I want to make sure everyone here understands what has been happening. Patricia has been creating her own rules, fining people for violations that do not actually exist, and threatening liens if people do not pay. I have talked to dozens of neighbors who have been hit with these bogus fines. This is not just a mistake or an oversight. This is a systematic pattern of abuse. Several people in the audience applauded. Patricia's face turned red. You are twisting this into something it is not. I have been trying to maintain property values and keep this neighborhood looking nice. If that means enforcing standards, then yes, I have done that. A man stood up in the back. You fined me $300 because you said my mailbox was dented. There was a tiny scratch on it from when someone hit it with a newspaper. That is not about maintaining property values. That is about you finding excuses to collect money. Rachel, the single mom I had talked to, stood up next. You fined me $500 because my kids drew on the driveway with chalk. It was washable chalk. It was gone the next time it rained. You called it graffiti. More people started speaking up, sharing their stories. The room filled with a chorus of complaints about Patricia's enforcement actions. The other board members looked increasingly uncomfortable as the extent of the problem became clear. Howard held up his hands to quiet everyone down. Okay, I think we have heard enough. The board needs to vote on several matters tonight. First, we need to vote on whether to rescind all violation notices and fines issued based on the architectural guidelines that were not properly adopted. Second, we need to vote on whether to remove Patricia Cromwell as board president. And third, we need to discuss implementing better oversight procedures to prevent this from happening again. Patricia stood up abruptly, her chair scraping loudly against the floor. You cannot remove me. I have done more for this HOA than anyone. I have spent countless hours dealing with violations, attending meetings, managing the finances. You are all acting like I am some kind of criminal when all I have done is my job. Linda spoke up, her voice calm but firm. Patricia, your job is to enforce the properly adopted rules, not to make up your own. You have overstepped your authority and you have created legal problems for the HOA. We appreciate the time you have put in, but this cannot continue. The vote to rescind the improper violations was unanimous, 5-0. Patricia abstained, sitting with her arms crossed and her face set in a furious scowl. The vote to remove Patricia as president was 4-1, with Patricia being the only dissenting vote. She slammed her hand on the table. This is a coup. You are all going to regret this when this neighborhood falls apart without my leadership. She stormed out of the meeting, leaving her papers scattered on the table. The room was silent for a moment before people started talking again, some relieved, others still angry about what they had been put through. Howard was elected as the new board president, and the board committed to conducting a full audit of all HOA finances and enforcement actions from the past 5 years. They also agreed to issue refunds to anyone who had paid fines based on the invalid architectural guidelines. I thought that was the end of it. I was wrong. 2 months later, I received a call from Howard. "Stephen, we have a problem. During the financial audit, we discovered that a significant amount of money is missing from the HOA accounts. We are talking about over $40,000 that cannot be accounted for." "What do you mean missing?" "The records show deposits from homeowner dues and fine payments, but there are withdrawals and transfers that do not match up with any approved expenses." Patricia was the one who had primary access to the accounts and handled most of the financial transactions. "We have handed everything over to a forensic accountant, and it is not looking good." The forensic accountant's report came back 3 weeks later. Patricia had been embezzling money from the HOA for at least 3 years. She had been writing checks to fake vendors, making transfers to personal accounts, and pocketing cash payments from homeowners. The violation notices and excessive fines had been part of a scheme to generate more cash flow that she could steal. The board filed a police report, and detectives from the Scottsdale Police Department started an investigation. I was interviewed as part of the investigation since I had been one of the first to challenge Patricia's actions. The detective, a veteran investigator named Sergeant Tom Rodriguez, told me this was not the first time he had seen HOA board members engage in financial crimes. "It happens more often than you would think," he said. "Small HOAs especially can be vulnerable because there is not much oversight. People like Patricia see all this money flowing through the accounts and convince themselves they deserve a little extra for their hard work. Then a little extra becomes a lot." Patricia was arrested on a Thursday morning in late September. The charges included theft, fraud, and forgery related to the fake vendor checks. The local news picked up the story, and it ran as a segment on the evening news about HOA corruption. I watched Patricia being led out of her house in handcuffs, still maintaining that defiant expression like everyone else was wrong and she was the victim. The HOA hired a lawyer to pursue civil claims against Patricia to recover the stolen money. Her house went up for sale a month later, presumably to pay legal fees. The criminal case moved slowly through the court system, but by the following spring, Patricia pleaded guilty to multiple felony charges in exchange for a reduced sentence. She was ordered to pay restitution to the HOA and sentenced to 3 years in prison. The board implemented new financial controls, including requiring 2 signatures on all checks, quarterly independent audits, and better transparency in reporting to homeowners. Howard turned out to be a much more reasonable president, and the atmosphere in the neighborhood improved dramatically. As for the violation notices Patricia had sent me, they became a useful reminder about the importance of knowing your rights and not being intimidated by people who abuse authority. I framed the original orange envelope and hung it in my garage as a conversation piece. But the story did not end with Patricia's conviction. A class action lawsuit was filed by several homeowners who had paid thousands of dollars in invalid fines over the years. They argued that even though the HOA was issuing refunds, they deserved additional compensation for the stress, harassment, and in some cases damage to their credit when Patricia had filed bogus liens against their properties. I was named as one of the lead plaintiffs in that lawsuit. Our attorney, Jennifer Hayes, argued that the HOA board had been negligent in their oversight and that the HOA insurance should cover damages for the harm caused by Patricia's actions. The HOA's insurance company initially tried to deny coverage, claiming Patricia's criminal acts were not covered under the policy. Jennifer fought that denial, arguing that the board's negligence in supervising Patricia was covered, and the insurance company eventually settled. The settlement provided payments to affected homeowners based on how much they had paid in invalid fines. Some people received a few $100s, others received several thousand. More importantly, the settlement required the HOA to implement training for all board members about proper governance and legal compliance, and it established an ombudsman position where homeowners could report concerns about HOA actions without fear of retaliation. Throughout this whole process, I learned more about HOA law than I ever wanted to know. Arizona has specific statutes governing HOAs, including requirements for record keeping, financial transparency, and enforcement procedures. Many HOAs operate in a gray area where they are not technically breaking the law, but they are not following best practices either. Patricia had gone way beyond that gray area into outright fraud, but her ability to get away with it for so long was enabled by a lack of oversight and homeowners who did not know their rights. I started attending HOA board meetings regularly, not because I wanted to be on the board myself, but because I believed in accountability. I encouraged other neighbors to get involved too. Frank, my retired teacher neighbor, actually ran for the board the following year and won a seat. He brought a level of professionalism and common sense that had been sorely lacking. The neighborhood itself underwent a transformation. Without Patricia's reign of terror, people felt more comfortable actually living in their homes without constant fear of violation notices. Kids played in yards, people parked on the street when they had guests over, and minor aesthetic imperfections were tolerated as part of normal life. One funny incident happened about a year after Patricia's arrest. Someone put up a Halloween decoration that was admittedly over the top, a 12-foot inflatable skeleton that towered over their garage. The old Patricia would have had a violation notice on their door within hours. Instead, the new board sent out a light-hearted email reminding everyone that decorations should be taken down within a reasonable time after the holiday, and complimenting the homeowner on their festive spirit. The skeleton came down on November 2nd, and everyone moved on with their lives. I also learned that our situation was not unique. I connected with homeowners in other Scottsdale subdivisions who had similar stories about overzealous HOA boards. Some were dealing with their own Patricias, petty tyrants who treated the HOA like their personal kingdom. Others had boards that were just incompetent or lazy, failing to maintain common areas or enforce rules consistently. There was a growing movement in Arizona to reform HOA laws to provide more protection for homeowners. State legislators introduced bills that would require better financial transparency, limit the fees HOAs could charge for document requests, and create an easier process for homeowners to challenge improper fines. The real estate industry lobbied against some of these reforms, arguing that HOAs needed flexibility to govern effectively, but homeowner advocacy groups pushed back hard. I testified at a legislative hearing in Phoenix about my experience with Patricia and the invalid violation notices. It was surreal standing in front of a committee of state representatives and senators, telling my story and arguing for legal changes. I was not a naturally political person, but this issue had affected me directly, and I wanted to make sure other people did not have to go through what I had gone through. The bill that eventually passed was not as strong as advocates wanted, but it did include some important provisions. HOAs were required to provide free copies of governing documents to homeowners upon request. Fines could not exceed certain amounts without a hearing, and homeowners had the right to challenge violations through an expedited arbitration process before any liens could be filed. These were small victories, but they mattered. The goal was to shift the power balance slightly back toward homeowners and create more accountability for HOA boards. Meanwhile, Patricia's criminal case had consequences beyond just her conviction. The prosecutor's office started looking more closely at HOA financial crimes in general. They discovered that several other HOAs in the Phoenix metro area had similar problems, with board members or management companies embezzling funds. A task force was created specifically to investigate HOA fraud, and over the next 2 years, more than a dozen people were charged with crimes related to HOA theft and corruption. This increased scrutiny made a lot of HOA board members nervous, which was probably a good thing. Boards started implementing better controls and being more transparent about finances. Management companies that handled HOA accounts had to undergo more rigorous audits. The whole system became more professionalized, which reduced opportunities for people like Patricia to exploit their positions. I eventually became friends with several of the other homeowners who had been targeted by Patricia. We formed an informal support group where we shared information and strategies for dealing with HOA issues. Mike, the guy who had been fined over his house number plaque, became particularly involved. He created a website documenting best practices for HOA governance and providing resources for homeowners facing improper enforcement actions. Rachel, the single mom, successfully sued Patricia personally for emotional distress related to the harassment she had experienced. Patricia's claims that she was just doing her job did not hold up in court when evidence showed she had targeted Rachel repeatedly with trivial complaints while ignoring similar or worse violations by other homeowners. The jury awarded Rachel $25,000, though actually collecting it was difficult since Patricia had spent most of her money on legal fees. As for me, I settled into my house and my neighborhood with a much clearer understanding of how things worked. I kept copies of all the relevant documents in a well-organized file. I documented any interactions with the HOA in writing. I knew my rights and was not afraid to assert them when necessary. The whole experience had taught me that most systems rely on people not pushing back. Patricia had gotten away with her violation scam for years because people assumed she had authority and that fighting back would be too expensive or too much trouble. Once someone actually challenged her, the whole house of cards collapsed. I also learned that community involvement matters. The reason Patricia had been able to operate unchecked for so long was that most homeowners did not pay attention to what the HOA board was doing. They did not attend meetings, they did not ask questions about finances, and they did not run for board positions themselves. That apathy created a vacuum that Patricia filled with her own agenda. After everything that happened, Attendance at HOA meetings increased dramatically. People actually read the meeting minutes that were emailed out. When the board proposed changes to rules or spending, homeowners asked questions and demanded explanations. The board had to be more responsive and transparent because they knew people were watching. It was not perfect. There were still disagreements about enforcement priorities and how strictly rules should be applied. But those disagreements happened through proper channels, with actual debate and voting, rather than through arbitrary edicts from a single person on a power trip. I ran into Patricia one more time, about 2 years after her arrest. I was at a grocery store in North Scottsdale, and I saw her in the produce section. She had aged noticeably, her hair grayer and her face more lined with stress. She saw me at the same time I saw her, and for a moment we just stared at each other. I considered just walking away, but something made me approach her. "Hello, Patricia." She looked uncomfortable, shifting her weight from foot to foot. "Stephen, I heard about the lawsuit." "Yeah." "It has been quite a process." There was an awkward silence. Then Patricia said, "I suppose you think I got what I deserved." I thought about that for a moment. "I think you made choices that hurt a lot of people, and you faced consequences for those choices." "I do not take any pleasure in what happened to you, but I also do not feel bad about standing up for myself and others." Patricia's expression hardened. "I was trying to maintain standards. Everyone wants to live in a nice neighborhood, but nobody wants to follow rules." The problem was not enforcing rules. The problem was making up rules that did not exist and using them to collect money that you then stole. If you had just done your job properly, none of this would have happened. She did not have a response to that. After another moment of silence, she turned and walked away, leaving her shopping cart in the aisle. I felt a mixture of emotions watching her go, pity and anger and relief all mixed together. The final chapter of the legal saga came 3 years after I received that first orange envelope. The civil suit against Patricia concluded with a judgment that she would likely never be able to fully pay. Her house had sold, but after paying off her mortgage and legal fees, there was not much left. She was working at a retail job, and her wages were being garnished, but it would take decades to pay back what she had stolen. The HOA received a large insurance payout that was used to replenish the depleted reserves and fund capital improvements that had been deferred during Patricia's tenure. New playground equipment was installed in the community park. The landscaping in common areas was upgraded. Streets were resurfaced. The neighborhood physically improved in visible ways. More importantly, the culture changed. People trusted the HOA board again, because the board had earned that trust through transparency and accountability. When issues came up, they were addressed through proper procedures rather than through autocratic demands. I thought a lot about what the whole experience meant in a broader sense. HOAs are strange entities, private governments that wield significant power over people's homes and lives, but operate with relatively little oversight. When they work well, they can maintain property values and provide amenities that individual homeowners could not afford on their own. When they work poorly, they can make people's lives miserable. The key difference seemed to be accountability. HOAs that functioned properly had engaged homeowners who paid attention and board members who took their fiduciary duties seriously. HOAs that became problems had apathetic homeowners and board members who either did not understand their responsibilities or actively abused their positions. Patricia was an extreme case, but the underlying dynamics were common. People got on HOA boards for various reasons, some wanting to serve their community and others wanting to control their environment or feel important. Without proper checks and balances, the latter group could do a lot of damage. I shared my story with local media several times over the years, hoping it would encourage other homeowners to be more proactive. I gave interviews to newspapers, appeared on local news segments, and even did a podcast about HOA governance. The message was always the same. Know your rights, read your governing documents, and do not be intimidated by people who claim authority they do not actually have. The legal principle that ultimately saved me and many other homeowners was simple. HOAs can only enforce rules that are properly adopted according to their own governing documents and state law. Patricia's architectural guidelines had no legal weight because they were never approved through the required process. Her violation notices were meaningless because they were based on unenforceable standards. When the case could have gone to court if Patricia had been foolish enough to try to enforce her fake fines, any judge would have dismissed her claims immediately. The CCRs were the controlling document, and they did not support her position. Everything else she had created was just paper with no legal authority behind it. That realization empowered not just me, but dozens of other homeowners who had been living under Patricia's thumb. Once people understood that her threats were empty, they stopped being afraid. And once she lost the ability to intimidate people, her whole scheme fell apart. The irony was that if Patricia had simply done her job properly, enforcing the actual rules in the CCRs fairly and consistently, she probably could have remained HOA president for many more years. The rules that actually existed were reasonable and had genuine support from homeowners. But she could not help herself. She wanted more control, more power, more money, and that greed ultimately destroyed her. I still live in Saguaro Springs. My mailbox is still the same bronze color it has always been, matching everyone else's on the street. My front door still has seasonal decorations that are reasonable in size and taste, though I admit I get a little thrill every time I hang a wreath that is definitely more than 14 inches in diameter. My garbage can still go out on trash day and come back in when I get home from work, whenever that happens to be. The neighborhood is quiet and pleasant. Kids ride bikes down the sidewalks. People walk their dogs in the evenings. Occasionally, someone paints their front door or plants new flowers, and nobody sends them violation notices unless there is an actual problem. Frank retired from the HOA board after serving 2 terms. He said he had done what he set out to do, helping to restore trust and implement better governance practices. The current board is a mix of longtime residents and newer homeowners, all of whom seem to understand that their role is to serve the community, not rule over it. I keep the framed orange envelope in my garage as a reminder. Sometimes when I am working on projects out there, I glance at it and remember how angry and helpless I felt that morning when I found it wedged in my door frame. Then I remember how I chose to fight back instead of just paying the fines and hoping the problem would go away. That choice made all the difference, not just for me, but for everyone in the neighborhood who had been suffering under Patricia's abuse. One person standing up and saying, "No, this is not right, this is not legal," created a cascade of consequences that ultimately brought down a corrupt system. It is a lesson I have carried into other areas of my life. Authority figures, whether they are HOA presidents or bosses or government officials, only have the power we give them. When they overstep their legitimate authority, we have the right and the responsibility to push back. It is not always easy and it is not always comfortable, but it is necessary. The legal system, for all its flaws, ultimately worked the way it was supposed to. Patricia sent violation notices that had no legal weight. When challenged, those notices were revealed to be baseless. When her broader pattern of misconduct came to light, She faced both civil and criminal consequences. The system bent toward justice, slowly but surely. I occasionally get emails from people around the country who have found my story online and are dealing with their own HOA nightmares. I try to respond to all of them, offering what advice and encouragement I can. The details vary, but the themes are usually similar: overzealous boards, unclear rules, intimidation tactics, threats of fines and liens. My advice is always the same. Read your governing documents carefully. Document everything in writing. Do not be afraid to consult with a lawyer if necessary. And remember that HOAs must follow their own rules and state law. They cannot just make things up as they go along. Some people take that advice and successfully challenge improper HOA actions. Others decide it is not worth the fight and either comply or move. I understand both choices. Not everyone has the time, energy, or resources to wage a legal battle with their HOA, even when they are in the right. But I am glad I fought. I am glad I did not just pay those $850 in bogus fines and hope Patricia would leave me alone, because she would not have left me alone. She would have kept finding new violations, kept demanding more money, and kept making my life difficult for as long as I let her. Instead, she is the one who faced consequences, and a whole community is better off because someone finally stood up to her. That feels like the right outcome, even if it took years and a lot of stress to get there. The Saguaro Springs subdivision is not perfect. We still have occasional disputes about where people park, or how loud parties should be, or whether someone's landscaping is an eyesore. But those disputes are handled reasonably, with conversations and compromise, rather than with violation notices and threats. The HOA serves its proper function, maintaining common areas, organizing community events, and enforcing reasonable standards that preserve property values without being oppressive. Board meetings are productive rather than contentious. Finances are transparent and properly managed. Homeowners feel like they have a voice. It is what an HOA should be, and it is a testament to the work that many people put in after Patricia's removal to rebuild trust and create better systems. Howard deserves a lot of credit for his leadership during that transition. Linda and the other board members who stood up to Patricia also played crucial roles. But I also think the homeowners themselves deserve credit for staying engaged and holding the board accountable. It would have been easy to slip back into apathy once Patricia was gone, assuming everything would be fine now. Instead, people continued to pay attention, continued to ask questions, and continued to participate in the governance of their community. That ongoing engagement is what prevents another Patricia from emerging. As long as homeowners are watching and willing to speak up when something seems wrong, the HOA board has to operate with integrity. The moment that vigilance lapses, the door opens for abuse. I have become something of an HOA governance nerd over the years, reading about cases from around the country and following legislative developments. The problems we faced in Saguaro Springs are not unique to Arizona or even to the United States. Anywhere you have homeowners associations or similar entities, you have the potential for abuse of power. The solution is not to eliminate HOAs entirely, which would be impractical given how much of American housing is now subject to HOA governance. The solution is to create better legal frameworks, better oversight mechanisms, and better education for both homeowners and board members about their rights and responsibilities. Some states have done a better job of this than others. California, for example, has extensive HOA regulations that provide significant protections for homeowners. Florida has an ombudsman office specifically dedicated to resolving HOA disputes. Other states have much weaker laws, leaving homeowners with few options when faced with abusive HOAs. Arizona has made progress, but there is still room for improvement. The reforms that passed in the wake of cases like ours were helpful, but they did not go far enough in some areas. There are still too many opportunities for HOAs to act improperly, and too many barriers for homeowners trying to challenge those improper actions. But change happens slowly, especially when it involves reforming established systems. The fact that Patricia was held accountable, both criminally and civilly, sent a message to other HOA board members in Arizona. The fact that our HOA successfully restructured and improved sent a different kind of message about what is possible when people work together. These days, when I tell people I live in an HOA, they often groan and share their own horror stories. I get it. HOAs have a bad reputation, often for good reason, but I also try to convey that it does not have to be that way. HOAs can function properly when there is good leadership and community involvement. My experience fighting Patricia's invalid violation notices taught me more about civic engagement, legal rights, and community organizing than I ever expected to learn. It was frustrating and stressful and time-consuming, but it was also empowering. I discovered that I had more power than I thought I did, and that standing up for principle actually could make a difference. That first orange envelope, demanding $850 for violations that did not exist, seemed like a disaster when I found it on my door frame. In retrospect, it was an opportunity, a chance to challenge an unjust system and create real change. I am grateful I recognized that opportunity and had the courage to pursue it. The house I live in is still the same physical structure it was when I bought it, but it feels different now. It feels truly like mine, not subject to the arbitrary whims of someone on a power trip. The neighborhood around me feels like an actual community, where people look out for each other instead of looking for violations to report. That transformation did not happen by accident. It happened because people chose to fight back against injustice, to demand accountability, and to work together to create something better. It happened because invalid violation notices were exposed as having no legal weight, and the person issuing them faced consequences for her abuse of power. The story could have ended differently. If I had just paid those initial fines, if other homeowners had not come forward with their own experiences, if the board had not taken action, Patricia might still be in power today, still sending out bogus violation notices, still embezzling HOA funds. But that is not what happened. Justice prevailed slowly and imperfectly, but ultimately decisively, and that makes all the difference.